Dzień dobry Państwu, witam wszystkich uczestników dzisiejszego seminarium. Ladies and gentlemen, I'm pleasant to welcome you to the next Allerhanda Institute Open Seminar in series Regulation Enhancing the Competitiveness of the Economy. Very important topic, I think. Today we start English series of our seminar. Today's seminar will present the findings of legal and comparative research on company law in Poland and in Spain, conducted by the team consisting of ladies first, Dr. Paula del Val Talens, assistant professor from the University of Valencia, legal department, and Dr. Ariel Mucha, assistant professor from Pedagogical University of Krakow and Allerhanda Institute, my colleague. The subject of the study were companies that allow the small numbers of people to conduct business under the condition of limiting the liabilities of all partners for the company's obligations. In Poland, these are mainly the limited liability company, spółka z ograniczoną odpowiedzialnością, and a simple joint stock company, prosta spółka akcyjna. In Spain, this is the more complicated, Sociedad Limitada or Sociedad de Responsabilidad Limitada, or Sociedad Limitada Nueva Empresa, Sociedad Limitada de Formación Sucesiva. Dear Cervantes, forgive me my Spanish. But both company law systems have been the subject of the numerous reforms in the last 20 years. This research, these findings, are the first that compare state-of-the-art, the Anno Domini 2020. I'm sure that our viewers are so curious I am about the similarities and differences between these two legal systems. That more, so the systems had different origin in the start, that shaping the company law in these both countries, and consequently upholding certain assumptions. I hope we have a very interesting lecture or discussions, both of our experts, Paula and Ariel. Floor is yours. Thank you very much for coming, and please start the message.
Thank you. Thank you, Wojciech. Hello to everybody. I must start with say that it is a great pleasure for me. It was a great pleasure, but I think it will be continue to work with you, Paula, and you have so much impact on this project. I received so much feedback about Spanish law from you. About the system, to be honest, I have no idea. There is a huge geographic difference between Poland and Spain, and this is also the case when it comes to the knowledge about this. I think fascinating corporate law. Corporate law which grab from so many different experience. Our Polish law is based mainly on the solution embraced by German legislation, I would say, when it comes to the private company. You are not only as a Spanish representative of corporate doctrine, you don't only refer to German experience. This solution firstly introduced in the form of GmbH, Gesellschaft mit beschränkter Haftung, but I think in recent times you also take much from the Anglo-Saxon system. So yeah, that's something what I find it very fascinating about Spanish law, and what Polish lawyers, in particular Polish lawyers, may learn more. There is not only German legal system, there is not only Anglo-Saxon systems, but there is much more legal systems that are very interesting, maybe even looking from the perspective of economy. They are more similar to our situation here in Poland. So maybe it is better to look, for example, to the Spain solution rather than only concentrate on what happens in, for example, Germany. As we will see today, we turn our eyes also on other legal systems, like, for example, Anglo-Saxon, some Anglo-Saxon solutions. Okay, Wojtek said much about our project, so I will not repeat all of this. So you know now why we choose this topic. There is not much about Spanish law in Polish doctrine, and I assume that this is the case also when it comes to the Spanish legal doctrine. So this project was intended to close this loophole. Second reason, when I think about closed corporation, so closed company, it is a company with small number of shareholders, where in many cases shareholders are involved in the management of on company, and there is some restriction on transferability of shares. And Wojtek said which legal forms are mostly what we call closed companies. So in Poland, spółka z o.o., PSA, and I will not repeat these names for Paula will do much better in the moment. So that's why we choose this kind of forms, because they normally fulfill those conditions of being private companies. And what is interesting about private companies in Europe, they are full of innovation in the last 20 years. After court's decision, European Court of Justice decision in cases like Centris, Übersehung, and Inspire Art, what occurred in Europe is called regulatory competition. So many member states made some improvement in the legal system, pick up some solutions which were never associated with the system. The most remarkable example is in Germany, where minimal legal capital was decreased in Unternehmengesellschaft to €1. Something unthinkable, in my opinion, 30 years ago, 20 years ago. So many happened in this area in last 20 years, and Spain was one of the first, in the first place, to change the company law. If I read books about private companies in Europe, books or articles, they always starting with what happened in 2003 in Spain. So you were at the beginning of the revolution of private companies, and Poland also make some changes, I would say, in particular about online registration of companies. But in last 2 years, much more happened. We I will explain in just a moment. But we have some new form, which is completely different from our current experience, our current legislation, so-called simple joint stock companies. And this form of company is reflecting much more solutions that are characteristic for Anglo-Saxon system. And we will talk about this during our meeting. Okay, because my introduction should be also very short and dangerously extended too much. Okay, we got first slide for some minutes already, and this is for people who are watching us. You can see this legal form at the first place, starting with Polish spółka ZO, czyli this LLC, Polish typical LLC company. And then we got also this new form, joint stock, simple joint stock company, in Polish spółka akcyjna, which will be, I hope so, it will be enforced from the 1st July 2021. I had hope, I had much hope. I had hope in that because this entry into force of this new legal form was postponed twice already. There are some problems with accepting new solutions in Poland, as you may see, but I hope that this new deadline it will be final. So from the in the mid of 2021, there will be this new simple joint stock company. Okay, this is the kind of introduction. And Paula, if you can say a few words about development of Spanish corporate law, because it is by itself very interesting.
Yes, of course. Good afternoon, everyone. It is my pleasure being here today, sharing the floor with Ariel. Yes, of course. If I had to introduce someone to the Spanish framework, I would first anticipate that in Spain we've evolved in a way where public companies and private companies, both forms, are actually suitable for small undertakings. So one should take into account, for instance, that in Spain, differences between the public company and the private company, leaving, of course, aside public listed companies, are not so wide. So many solutions that we will discuss today may also be applicable for public companies. As I was saying, we've had a great number of reforms, and as Ariel has perfectly described, our system has mostly looked at the German system, but also probably the Companies Act in the United Kingdom was a very strong influence for us. And we have always had Italy as a system for our own reflection. But as Ariel says, it is probably the time now that we start focusing on other legal systems with which we may share some features. For instance, it could be the case with Poland, since it is very likely that the kind of undertakings that are most widespread are also the same, and they also tend to use company forms. Cervantes would actually be very proud that we were here today discussing not only the private company, which specifically we call Sociedad de Responsabilidad Limitada, but these two particular forms of Sociedad de Responsabilidad Limitada that, as Ariel says, Spain has had for some time now, and some comparative legal systems have always called their attention. I don't know, Ariel, if you want me to describe them now, should I do that?
Mm-hmm. Maybe if you may say a few words why you got this different legal form like SLNE and SLFS. We use this abbreviation.
Yes, that should be simpler. Yes. As discussed, this Sociedad Limitada Nueva Empresa, this SLNE, was enacted in 2003 because Spain wanted to immediately enforce some of the guidelines that the European Union, but other institutional frameworks at the global level were pointing at. We're pointing at the need to create private companies online with low cost to limit transaction costs. So Spain took that up and created this Sociedad Limitada Nueva Empresa by enabling that it was created in a very short period of time by using template articles of association. So you could not draft them yourself, but you would have to adhere to attach to the ones that were presented as a model. The thing is, short after that, the system to actually create other types of private companies and register them online was set up. So in a very short time, the SLNE was outdated. If we see the numbers, the first year that this legal form existed, quite a large number of them was created, and this went on for a few years. But now, as I was discussing earlier with Ariel, we see around 10 SLNEs created every year, and this is because to be able to register a company, a private company online by using also a template, articles of association in a very short time and have it registered in about 6 hours. So if you have that, you actually do not need to go to a very rigid SLNE. We can discuss that later, but the SLNE is quite rigid. And then a few years later, we were following the international discussion on, let's say, the fading away of legal capital as presented by very important scholars around the world, this crisis of the legal capital. So Spain decided to go for that and to create this SF, Sociedad Limitada, FS, de formación sucesiva, where one can actually start a private company, a Sociedad de Responsabilidad Limitada, with a minimum share capital that is under the legal share capital, that is 3,000 euros. So amount of money under 3,000 euro, including just €1, you can actually start a company, a private one under Spanish law. And just a number of measures are in place to try to protect stakeholders, namely creditors, during the period of time where the company does not have a minimum capital that reaches this 3,000. So that should be, and as I was saying here, we took the German example, as Ariel was saying, of this UG, where you could actually do the same, create a company with that amount of minimum share capital.
Mm-hmm. Okay, thank you. So there were some experiments, and not all were successful, as this Nueva Empresa form of company showed. Okay, let's turn to the next point, our main analysis, and we are starting with how to set up a company. And the first issue we analyze is the autonomy of the parties. And you must always bear in mind that we are in company law, so this autonomy is relative. It is obvious that you can't change everything. You can't influence the method of setting up a company. You can't change rule of responsibility for the members of the board, but you can change to some extent the internal structure and in particular the relation between shareholders. And what changed in Polish law, and I'm looking at this new joint, simple joint stock company, that this autonomy was made, I would say, wider. And that was made by introduction precise provision that, for example, allow shareholders to issue lay down that they may issue, for example, non-voting share. They may, for example, prescribe voting caps, or so there are some departures from the proportionality principle, and there are also more information in legal act about what kind of individual rights may be vested on shareholders. So that's change in Polish law. What about Spanish law about this autonomy? Because it is limited, but as I wrote on this slide, by authorities. This is not like legislator decision to limit autonomy, but this was rather that follows from the control of public institutions.
Yes, exactly. You're absolutely right. So under Spanish law, we have Article 28 of the Spanish Companies Act, which is the Ley de Sociedades de Capital. And this provision actually states that any provision that the shareholders may consider, as long as it is compatible with the law, and good faith and public policy, should be or could be enacted in the Articles of Association. This would be a general party autonomy clause, like the typical ones we find in contract law. So supposedly, the Spanish Act provides a very wide leeway for shareholders to provide in the articles many different solutions. As Ariel said, non-voting shares, for instance, are perfectly acceptable under Spanish law. Not voting caps, those are not so easily acceptable. And we could also use the articles to design or to define the rights, as long as this is compatible with the mandatory provisions in the Act. But what we see is that systematically, the authority that is in charge of reviewing registration, that is the commercial register in Spain, which is el registro mercantil, both the registro mercantil and the administrative authority that is in charge of any review that one might submit to the register's decision, they are extremely restrictive with regards to party autonomy. So we see lots of provisions that are technically compatible with the law, even if they may be interpretative problems, and they are systematically rejected. So just to give you an example, for instance, shareholders' duties are actually one of the very much discussed topics under EU law, specifically in closed companies. And in Spain, you are absolutely not allowed to mention specific duties of shareholders. So for instance, fiduciary duties of the shareholders, you cannot describe them in the Articles of Association. Only you may be allowed to do it if you express them in the form of an ancillary or auxiliary obligation, these specific contributions that are not part of share capital. Otherwise, they will be systematically rejected no matter how you express them. So this is just because of the position of the register and the administrative authority, that is the Dirección General de los Registros y del Notariado. What they do is they systematically push this information, this kind of agreements by shareholders, to actual shareholders' agreements. This is outside the scope of the Articles of Association, just in the form of shareholders' agreements.
Mm-hmm. Okay, I didn't heard, because I'm thinking how it looks in practice in Poland, that there is a problem of systematic restrictive approach of, for example, register courts. Polish courts suffer from many things, like in some cases errors or time-consuming procedure, but I wouldn't say that this is a systematic approach that we will be very restrictive. Maybe there is some tendency to extend control as regards documents. They checking and which were filled by the parties to the corporate contract. But I would be far from saying that the Polish courts are very restricted. And yeah, both systems, so in Spanish and in Poland, we get these two institutions of control: notary and public authorities in the form of courts. That's quite similar. What we find is a difference, I think, is about online setting up a company. There was something surprising for me because in all cases, in all companies we mentioned here, there is an opportunity to set up an online procedure. But in Poland, when you are choosing online procedure, there is no notary. So we departed from this kind of involvement of this institution in the process of establishing a company. But in Spain, even online, the notary is present. Am I right?
You are absolutely right. So we were one of the very reluctant countries in the discussion on digitalization. So the one that led to the European Directive on Digitalization that needs to be transposed in the following years. So Spain was one of the pro-notarial intervention countries. We have a very strong tradition of notaries, just in a way similar to Austria and somehow Germany too. So we were one of the ones pushing for that. The idea is that we do now have the possibility to create all sorts of private companies online, but the intervention of the notary public is still a requirement. So if you start a company using the online platform, the online system, you are going to be required, as of today, to set up an appointment with a notary and to physically attend to the notary's office so that you are specifically identified and informed about the procedure that you're about to undertake. The identification, so the identity of the parties actually intervening in the legal act of forming a company, is the one that today, in accordance with Spanish law, you can only do in this way. But as Ariel is pointing out, Spain is aware of the fact that we need to modify this to be in compliance with the European Directive on Digitalization. So it is now foreseen, we are going to, it's not prepared yet, the draft act, but we know that we are going to have to modify this to be in compliance with the directive. And in the near future, we are going to, this has already been decided, the notary is going to intervene in any case, but the interview with the notary public is going to be scheduled online because the directive precludes member states from obliging parties to actually appear physically in front of a notary. So the notary is compatible with the directive, but we are going to set up this online date with the notary public through the internet. So it will be part of the procedure. The notary will identify the parties intervening online.
So yeah, notary public is very strong in Spain. I would say it's amazing. I think it's so amazing, and I heard this idea that identity of shareholders will be checked, like they must be in the front of the camera, and the notary will look if they are similar to their photo and ID, and so on, so on. There was a huge discussion about the problem of checking identity, and ideas sometimes are crazy. Yeah, in last week, for example, here in Poland, I set up like 4 bank accounts, and each took me like 15 minutes. So why not the same with a company? All things was as regards bank account establishing, and I'm not doing any money laundering business. You sure? Always check on my phone. So yeah, I think that this is. I'm not saying that public notaries are not important, but not maybe in this case. Okay, turn to another issue, model article of association, and well, there is some difference between our systems. This is in Poland. If you are creating a company online, you must take advantage of this model article of association. There is no other choice, and there is little leeway as regard the provision of future article of association. There are some options, but not so much. Tell us about Spain.
Yes, okay, so that is, I believe, one of the points that we were discussing during the project, because there were differences between our system. So if you remember, I said before that the SLNE had actually model articles of association, and they were very rigid, very strict. Legal scholarship, but also practice, was a bit reluctant towards that. So I believe that is the reason why when we enacted the possibility to start up companies online, we established 2 alternatives. So option 1 would be the same as the Polish solution. You take these model articles of association, you accept them as they are presented to you, and the application is filed to the commercial register. And it is reviewed and accepted for registration, as long as it is correct, within 6 hours. Working hours after presenting the application, the company may be registered if the articles of association have not been at all modified and you just accepted the ones that are presented by the platform and the legal act. But you could alternatively choose to draft your own or to introduce modifications to the articles of association. So notaries are usually prepared to assess them and prepared to inform the parties about them if they would need to. And you could do that too and still use the online registration procedure. The only difference is that if you do that, if you choose to draft your own articles of association, the procedure will not be completed for registration within 6 working hours. But it'll take the average or the minimum, no, it's a maximum, sorry, the maximum legal framework, that is 15 days, 15 working days. It'll be done fully online, except for the part of the notary public. And the company may be registered as well, but it'll take 15 days, which is the time that the commercial register legally has to actually assess and review the articles of association that are not a sample or a model article of association. So they need to review them and they need time for that. So that would be the difference. Those options are available for online registration.
Yeah. So there are much more options that in Polish law. Rather strict as regards what is in the model article of association. Okay, time is flying, so let's go to the next slide. And this is capital required, another huge issue in the last 20 years, and probably the thing that changed the most in the corporate environment in Europe. The basis institution of capital requirements when we are thinking about closed corporation was this minimum initial capital. So if you wanted to create your business, you had to contribute in some form. That value is at least as prescribed in the law. And yeah, in Poland, that was time like 12 years ago, that this minimal requirement was 10,000 euros, around 10,000 euros. Nowadays, this is 1,000, so much lower. And in case of this simple joint stock company, there is no share capital at all. So there is even no requirement to put €1 or 1 zloty into this company. I think Spain is much similar in that regard.
That is right. So this form that you're about to enact would be similar to our Sociedad Limitada de Formación Sucesiva, following probably the Belgian example or even the German UG. So those, I would say, are the same specialty of closed company. In our case, as I said earlier, we can also start up a company that is a private one in this particular regime with any amount lower than 3,000. That is the minimum share capital for an SL, for a private company in Spain. And there are specific measures in place to prevent distributions from lowering the assets too much. So you, for instance, there is a cap for director remuneration, there is a cap on shareholder distributions, and there is also, for instance, the duty to allocate profits in the legal reserve continuously as to actually have assets to confront any kind of liability that may arise within that period where we are under the minimum share capital of 3,000.
Mm-hmm. Okay, and this minimal capital requirement was all about, maybe not only, but mainly serve as a guarantee for creditors that this company has some assets inside. So if we drop the idea of minimum initial capital, I think we should think about other methods, another mechanism of protection. And those are, for example, balance sheet test, which means that you may pay dividend only if the value of your asset exceeds the value of your debt. And Spain has it, yes?
Yes, so that is a very common and also a difficult discussion, because we somehow have different understandings of the different types of tests that we could apply, but that should be the case. So there is a sort of balance sheet test, if you want to call it, or maybe just simply a solvency test in the regime of this formación sucesiva. But we see them in many different places. So you see them, for instance, in Article 3, 4, right for shareholders if sufficient dividends are not distributed. And that provision is already built on the grounds of a solvency test, probably this idea that you can distribute in accordance to this previous judgment on the capability of confronting your own asset ratio. That is the general understanding. We're starting to accept it under Spanish law. It may take some time. And since, for instance, this SUP, this Societas Unius Personae, as a proposal on the part of the European Union, did not make it very far, and it was already building up on a solvency test, it may take more time to see it as a general rule for the whole company law. But we may evolve on that, no? Grow further.
Mm-hmm. Mm-hmm. And I will have one question about, we sometimes also call it insolvency test this is the case when company is already in insolvency state, and there is an obligation for directors to file for insolvency. And if they don't do this in the proper term, in Polish, and this is 30 days deadline, they will be liable to creditors. And as far as I know, also in Spanish, this rule applies, and I think that it comes from a German legal regime. As I remember, Article 64. Of the MBH Gazette.
Yes, I think this provision with differences is very present in many jurisdictions by now. The Spanish one also foresees it. So directors have the duty to file for insolvency, or if that is the case, to just liquidate the company whenever the legal cost for that applies. And if they don't do it accordingly, they will face liability for the debts of the company. So the idea is that they are responsible for the solvency test, although part of that solvency test in Spain is actually foreseen in the Insolvency Act as part of the requirements to file for insolvency. But the consequence is actually foreseen in the company's insolvency or not filing it at all. That gives rise to the liability of directors, just I would say in a very similar way to the Polish provision and also the article or paragraph 64 of the MBH Gazette.
Yeah. In Poland, this is a very serious business because there are many cases where directors are sued because they were late in filing for insolvency. And how much is serious? There are two provisions more or less exactly the same. One is in Corporate Law Act, Commercial Companies Code, and the second is, as you said, it's similar in Poland. We got also this provision in Insolvency Act, but what is interesting in Polish law, we got two provisions which make director liable almost for the same thing. Okay, and last but not least, this institution is called statutory tied-up reserve, which basically means that you must save some money for future, if company would be in future in some financial trouble. And in Poland, this institution was introduced alongside this new legal form, simple joint stock companies. And the statutory tied-up reserve must reach 5% of liabilities of the company. So this how much money will be in this reserve depends on the size of the company. I think that there are some difference in Spain at that regard.
Yes, I think that Polish provision is actually very well drafted. I don't know about enforcement, but the mechanism is very well suited for the purposes of a system that is trying to be more flexible. In the case of Spain, our provision is slightly more rigid. This is Article 4A of the Ley de Sociedades de Capital. And here, one of the measures in place for this Sociedad en régimen de formación sucesiva that we are discussing this afternoon, or one of the ones that we are discussing this afternoon, here the company is required to allocate at least 20% the net profits to the legal reserve, but without a limit. There is no limit. We would say the sky is the limit here. They just have to keep allocating 20% without a limit. That would be the difference here.
But if in the company there is 3,000 euros, there is no need to accumulate more capital on reserves. Yes.
Yes, that's right. But I would say as long as the capital is modified in that regard. So the idea would be that once you allocate enough to gather the minimum legal capital, you would probably need to decide whether you prefer to just modify the share capital in the Articles of Association, allocate that that's just in the articles, and then just prevent or exclude the application of this provision that requires you to have a 20% every year. I would say that should be.
Yeah, exactly. Yes, you said that this Polish provision is well drafted. The problem is we don't know how it works in practice because it may be enter into force in the mid of this year, because I'm speaking about simple joint stock company. Well, the problem is that there is no such requirement in typical Polish LLC, and some suggest that this is the main disadvantage of simple joint stock company, this obligation to put money on reserves. In normal company, you don't need to do this. So the question is obviously whether this obligation will discourage people from establishing a simple joint stock company in Poland. Okay, and last question about this company's capital. One last aspect is related party transaction. So the rules how to deal with the transaction between company and someone who is very close to the company, like shareholders or the member of the board, or, for example, family member of the board. We in Poland, we got in the simple joint stock company some general clause that every transaction between company and shareholder must be at arm's length. So based on condition that would exist in the transaction between equal partners, I would say. That's what at arm's length principle means. Yes, that will be a kind of a new provision. We have something what might be called general clause for related party transaction. What do you got in Spain? Spanish law.
I would say we have a similar thing, but it is not so general. So for the case of Spain, we would have to see first whether this is a matter of a conflict of interest on the part of the shareholder, or whether the conflict of interest actually affects the director. So the provision is different. The one for shareholders is Article 190 of the Spanish Companies Act, which has as a general rule that shareholders may vote and only has closed list for cases in which the shareholder might be prevented from voting. We also have specific rules for just shifting the duty to actually prove whether that is compatible with the interest of the company. But there, I would say for shareholders, we do not have anything similar to a general clause like the arm's length one you have for the Polish example. We would have something similar with regards to related party transactions for directors. And there, within the duty of loyalty, we have provisions to actually provide the directors with an authorization to conclude transactions with the company. And those need to be at arm's length. So to actually provide that authorization, to grant it to the director, the transaction needs to be at arm's length. We do have problems in closed companies with regards to family members. And this is because the provisions on directors do take into account the possibility that a person who is related to the director intervenes, the spouse, a son, a daughter. That is taken into consideration within the duty of loyalty of directors. And those transactions are prevented and need to be authorized. But we do not have anything similar with regards to shareholders. So we do have tons of discussion with regards to the extent to which we would need to extend those provisions for directors to shareholders. But the general approach is negative. The idea would be that closed companies do give rise to those sorts of conflicts in a more common manner than we would see them in public companies. And the approach is not as negative as one would imagine.
Okay. Yes, we must go to the next slide. So you said something about directors and duty of loyalty. So it's a good time to speak about vertical agent conflict. Yes, and this is also, it will be something new for Polish lawyers, monistic system of government. We are traditionally dualistic system, so we got the board of directors and a supervisory board within the structure of the company. But in the joint stock, simple joint stock company, so this new Polish form of the company, there will be options to choose between dualistic and monistic system. And well, it would be lovely to hear about what we are going to expect from the monistic system. And I must I must say that when there is a discussion in Poland about monistic system, there's always reference to Anglo-Saxon. I have some doubts if many people know that in Spain we have also monistic system.
That is yeah, I see that maybe you don't look at other smaller or let's say less internationally broadcasted systems, but I think the Spanish one would be a good one because we have a very long tradition of monistic systems. Actually, I would say Spain has been quite reluctant to anything related to a two-tier system, to a dualistic system, to have it in place. We only have it as far as the regulation on the European company imposes it. And I don't think we have one dualistic company in Spain, I would say. But the monistic system is actually quite simple. The first idea I would want to share is that a monistic system actually has in Spain at least, 4 different forms, 4 ways of being formed. One would be just having one director. So she would hold all the authority and all the power and manage the company. Then we would have other forms that the board might take, maybe them acting together in a joint way or acting severally. But probably the example that would be more relevant, the form of the board or the management organ that would be more relevant if a dualistic country is looking at us would be a board of directors. So an actual board composed by 3 or more members where decisions are actually taken by majority. So that would be the more similar approach to the one that a dualistic system has. And here, the only particular thing is that we have one structure where most of the members, or I would say all members, are subject to the same legal regime in terms of duties and liabilities, in terms of voting power. But at the same time, this monistic system enables to specify functions, in particular executive functions, upon one or more members of the board. So in this way, a monistic system where everyone is acting under the same legal regime actually enables creating differences in the board or within the board. So if you look at a complex or relatively complex board of directors under Spanish law, not necessarily in large companies, but in small undertakings, the board of directors is actually something very entrenched, something very typical for undertakers in Spain to actually opt for that. You see that the way in which they operate is not that far from how a dualistic system, a two-tier system looks like. The big difference, I would say, is that no worker participation is in place. No, the workers are not at all represented in the board. And I think that is the most significant difference here.
Yes, that's the thing we don't follow from the German legal system. We also don't have workers representatives, so this Mitbestimmung institution in our in general in our system. There are some exceptions. Okay, duties. You got non-executives and executives, directors. And we said something about filing for insolvency. There is some discussion in Poland about that. So in Spain, if you have a company in insolvency state, both executives and non-executives are obliged to file for insolvency. Am I right?
You are exactly right. So the general idea is that all of them are operating under the same duties of care and loyalty. And within the duty of care, we would say there is a specific duty to file for insolvency that is actually stated in the law. And all members are equally subjected to that provision. We do have, since 2014, provisions that are better suited to assess the liability of each director individually, to actually assess whether their specific legal regime and the specific functions that they had within the board actually modifies something or not. But we haven't seen cases where this clause has been applied, so we don't have much experience on its enforcement. But theoretically, if the board was organized in a way where one of the directors was specifically in charge of solvency matters, that is not typically the case, but it could be, we would have also grounds under Spanish law to maybe declare his liability in a preferent way, so more or with more grounds than with other directors. That should work in Spain, but we don't have much experience yet in applying this difference between members of the board in the monistic system.
So it doesn't make a difference if, for example, non-executive director appears in the company like one times in a year. He knows nothing about the financial situation of the company. There is no reason for excluding him for potential liability in case of insolvency. Yes?
Exactly, that is right. Under Article 237 of the Spanish Companies Act, all directors are jointly liable for duties arising from their function. And the description that Ariel just gave, this director that is not informed about how the undertaking is doing, that does not look at the annual financial accounts and is just receiving a remuneration from home and not attending board meetings, is under Spanish law called a doorman director, a dorming director, or whatever other name you may want to give him, but under Spanish law, he's equally liable. So probably the Spanish, by not actually intervening and properly exercising at least his supervisory function. So if he does not have executive power, it is according to the Spanish system because he is holding supervisory authority upon executives. So when filing for insolvency has failed, even if he was not aware of how the annual accounts were, he may be actually infringing his duty to supervise executive directors. So the ground would be the same.
Okay. So the next thing is if a legal person may be a member of the company, and there is yes as regards Sociedad Limitada. This is something which would be a heresy in Poland if I make a proposal to allow companies sit in the board. This is unacceptable. Many would say that it poses too much risk, and there must be always a real physical person in the board, because board is responsible for managing company. So do you agree that this risk really exists?
I would say that this is quite a matter of path dependence. So there are countries that have been familiar with this way of proceeding for many years. This is a French-influenced solution. French and Belgians, but also the United Kingdom, have applied it for years. So we are quite used to seeing legal entities as members of the board. We usually tend to say that this is typical for groups of companies, that it allows placing service companies, so companies that are offering management services, place them on the board. And that is acceptable under Spanish law, always as long as a natural person is appointed, the one acting all the time. This is also a French-inspired solution that we also see in the European company regulation. But many other countries do actually use this solution by means of a contract. So, for instance, in the German-influenced world, this is something that actually happens by use of managing contracts that have the very same contents or very similar contents as the ones we see for the contract of a board member. So, in the end, I would say it's just a matter of how the legal framework is actually used institution in place and confronting the liability or the transparency caveats that it may introduce. But if you are not familiar with it, if it's totally alien to your legal tradition, I probably would not suggest you introduce it, you create it ex novo, because it would just probably create a disadjustment in the idiosyncratic practices of the board, I would say.
Yeah. I think that the problem with taking liability from board members is, in practice, they are sometimes hard to find. That's one thing, and the second, in most cases, they don't have much money when compared to the debt of the company they manage. Okay, let's go to the duty of the members of the board. And yeah, I would like you to ask about this huge issue in Europe currently, in what interest in Spanish law directors should act. I would just mention that in Poland we are a country where shareholders primacy rule is very strong. What about Spain? Is there any difference?
I would have given you an answer last week, and that would be the Spanish system is exactly the same as the Polish one. There is a predominant shareholder value approach, although we do have sufficient scholarly support for a stakeholder-oriented approach in some matters. So, for instance, if you would ask whether donations are admissible under Spanish law, I would say yes, you could agree to a donation with the assets of the company as long as it fulfills certain requirements. You're allowed to enact CSR policies, you are allowed to be in compliance with the non-financial reporting directive. But I would, like last week, I would have said we are mostly a shareholder value approach with nuances. But as I was discussing with you earlier, Ariel, Spain just implemented the second shareholders' rights directive, 2 years delay, with a 2-year delay. And in this reform, we have modified Article 225, that is the duty of care. And within the duty of care, the Spanish legislature has introduced now something called the interest of the enterprise, of the whole undertaking, in a very vague way. And I've been informed that this change in the wording of the law is supposed to prepare the Spanish system whatever approach the Commission is going to take in the next sustainability package for corporate governance that we are expecting immediately, probably. So apparently Spain has already adopted that to be ready.
Yeah. But you're still saying that this is very vague. So probably there will be no practical. You said that this is vague, very vague provision. So probably I would assume that there will be no much impact on practice.
Exactly. I would say that whatever that provision is actually protecting or giving leeway for, we could already have it with a bit of argumentation on the grounds of legal scholarship in Spain. We could achieve that result.
But this is still one small step forward, I would say. Okay. I just looking at the topic that left. We have obviously business judgment rule issue, but because of it, I would turn to the shadow directors issue, because that is something which Polish corporate law doesn't know. There are some rules in the Insolvency Act that, for example, if a shadow director, his action caused the insolvency, a court may prohibit him up to 10 years from leading any business undertaking. But we don't have any trace of this institution in the Commercial Companies Code, which is in contrast with Spanish law, as I know.
Yes, indeed. So we've had it for some time now. In the last major reform, or I would say the one before last, because the last major reform is the one we had last week, probably. In the one we had in 2014, we actually enacted the two forms of shadow directorship that are most widespread in the literature. We would say strictly the de facto director, the one acting without being entitled to. That person is treated in the same exact way as if she was a de jure director, as if she had been formally appointed. And this regime also applies to what we call shadow director. In Spain, I would say that a shadow director is someone that is behind the de jure directors and is giving them instructions and guiding the company from the back, we would say. So those two ways of operating are treated under Spanish law in the same way as if this person was actually appointed formally. And as you say, Ariel, I found interesting because we do have this same kind of provisions, maybe drafted in a different way in the Insolvency Act too. So you would say that de facto directors in Spain have the same regime as the jure directors, or a very similar one in terms of liability, both in the companies and in the Insolvency Act.
Yeah. Well, maybe the reason that there is a difference between Polish Commercial Code and Polish Insolvency Law is that Insolvency Act was created by different people, and they took advantage of the solution from many sources, I would say. Also, one may say that maybe those people are more enlightened as regards new things, introducing new things in law. And by the way, they were connected to Allerhand Institute, who is a host of today's meeting. Okay, that was the issue of shadow directors and agency conflict. Last thing, horizontal agency conflict, so relation between different shareholders. And what we got in the closed companies, we get conflict between majority shareholders and the minority shareholders in many cases. And what I find interesting in the Spanish law is this 1% threshold. So you may challenge a resolution of general meeting only if you have 1% or more shares in share capital. And we had such discussion in Poland about this threshold, and such a rule was in Polish law, but it met with some negative assessment by the Polish Constitutional Tribunal in 2004, and just a short side from this judgment, justification of this judgment. This is breach of access of court, and this breach is evident. So there is no such a rule in Polish law, and there is no perspective to introduce this 1% threshold. So I'm curious how it works in Spain. There are some problems with this threshold, or this is a good measure, a good mechanism for preventing shareholders blackmail.
So that is supposed to be the idea, to try to establish a slight, at least a minimum economic interest in a 1%. As I discussed with you, we did not have a similar discussion. So I would say that constitutional problems with regards to company law are not that developed under Spanish law. I would say we would have leeway there to maybe develop our project further in that regard. So this discussion does not arise in Spain that much. We do not think that there is an expropriation of the right to private property, or that there is an impediment to the access to justice by having this threshold. So we just had it sort of historically, and we accept it. But what I would probably argue here is that under Spanish law, even if you do not have a 1% threshold, you could challenge a resolution of the general meeting either as an interested party. So maybe, for instance, you leave the company and afterwards you want to challenge it, you may qualify as a legitimate interest person. But more importantly, there is one type of resolutions under Spanish law, the ones that are considered to be contrary to public policy, and those can be always challenged at any time by no matter who, under Article 204. And these public policy resolutions are typically the ones that pose constitutional problems. So resolutions that are deemed contrary to private property, to the access to justice, to the right to be treated equally, for instance. Those are resolutions contrary to public policy under Spanish law, and they could be challenged by everyone. So maybe that would be the Spanish way of balancing out the threshold.
Yeah. Okay. Last thing to discuss, exit rights. So another method to resolve conflict inside the company. And when it comes to private companies, this exit right is not so popular, I would say, in Poland. Basically, if you are in minority and you are in conflict with the majority, you have problem. You are stuck within the company. And apart from some specific situation like restructuring procedures within the company, you can't basically leave the company. It will change to some extent when it comes to simple joint stock company. There will be a right for the shareholders to apply to the court, and the court may allow shareholders to leave the company, but there must be important reason. There are some commentaries who said that, for example, the reason might be that there is no payment in the form of dividend to shareholders. That might be important reason for such an exit. You are much richer as regards exit rights, as far as I know.
We could say richer, we could say bureaucratic, as you would prefer. So we do have many grounds for exit rights under Spanish law. We have Article 346 of the Spanish Companies Act that provides for legal grounds to actually leave. These are, for instance, that the purpose of the company, the objects clause, is strongly, intensely modified, that creates ex lege right to exit the company. And we have many others, or 2, 3, 4 others in a similar way, where the legislature has already balanced the possibility to exit. And I would add 2 things. The first thing is that we do not have anything like a good cause or important cause ground for exit. And that is actually seen with a lot of reluctance on the part of Spanish scholarship. So the idea is that our legislature has enacted specific grounds for exit, and we cannot consider there is a general clause for exit besides the specific cases foreseen in the law, or if that is the case, in the Articles of Association. But we do not see that to be something typical from the Spanish system, this good cause exit. And one of the typical exit problems that we had, and also the typical majority abuses that every jurisdiction confronts, is the one where the majority is economically exploiting the minority by not distributing dividends. So what the Spanish system did is to actually exit right for the lack of distribution of dividends, and that is today Article 348A of the Spanish Companies Act that actually provides with this right whenever at least 25% of profits that may be distributed are not actually distributed within a 5-year period.
Yeah. And this is my general impression that when you speak about corporate law, you are more precise. I think in your legislation, your legal acts are much more premises and indication how business should act, and so there are more certainty, I would say. But on the other hand, we may say that Polish law is more flexible. Okay, Paula, thank you so much. It was a huge pleasure for me to have this conversation about corporate law, and I hope that we fulfill our main aim. This presentation of comparison of two legal systems, Polish and Spanish, will get to Polish and Spanish academia, and maybe there is a sign for more future cooperation between academia in those both countries.
It was my pleasure, Ariel, discussing with you this afternoon. I always learn a lot when I'm discussing and working together with you. I'm grateful for the Allerhanda Institute for the invitation and the project, and I'm looking forward to continuing this collaboration.
Proszę bardzo.
Okay, thank you very much, you, Paula, especially, and Ariel, for very much consistent and interesting dialogue. This word is very in place, but our project have name dialogue between practitioner, between states, between lawyers, between different theories too. The word, the development of company law, according to your word, is becoming an increasingly phenomenon dynamic. At the same time, the stability of law ceased to be an important value of legislator and prevail over it the pursuit of efficiency understood of the reducing the cost of establishing and or operating companies. What is the best solution? I think this is not the answer, but this is a very interesting portrait of the states of the company law in both countries. Thank you very much once again. Now we finish our seminar. Let me introduce and invite you to the next one. Our next seminar, 26 April, will be devoted to the comparison of legal instrument of competitive policy. In this time in Ukraine and in Poland. That means in European Union. Our speaker will be Iwanna Czajkowska, the PhD students from the Jagiellonian University, and Jarosław Czajkowski, assistant professor from the University in Tarnopol at Ukraine. Thank you very much for time for us. Thank you very much for our speakers. Good night.